call the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. Let me introduce the panel. To my right is Justice Didkoff. To my left is Justice Brennan. I'm Justice Shin. We'll be hearing one case today, which is the Department of Children and Families versus Father. It's case number 2024 P27. As I know, council's aware, each side gets 15 minutes to argue. I understand the appellees will be splitting their time 8 minutes and 7 minutes, and there is no rebuttal in the appeals court. And the last thing I'll say is that this case is impounded, so please refrain from using the parties' names. So whenever you're ready.
Good morning, Your Honors. My name is, may it please the court, my name is Dana Schenebert, and I represent the father on the appeal of the termination of his parental rights. And for the court's information, father's in the courtroom today. I have two simple points to make for this panel today. And the first one is that father is entitled to raise the issue of reasonable efforts or inadequate services for the first time on appeal. And this court underscored that right, or that, yes, that right in adoption of Otto, which is an unpublished case of 2023, but it quotes adoption of Chad, which is a 2019 case. And it says, while it's well established that a parent cannot raise the claim of inadequate services for the first time on appeal, where a parent could have raised the issue more pointedly at trial, this court may review the claim where reasonable efforts and inadequate services were a theme that ran through the life of the case. Now, this case reaffirms that fairness in termination cases requires full examination of whether the state met its legal obligations and underscores that the appellate review should be broad when considering possible violations of due process as we have here. Now, when we talk about reasonable efforts and adequate services running as a theme in this case, if we look at the facts, DCF became aware that father was a putative father in February of 2021. They made their first contact with him 6 months later in August 2021. Now, during that phone call, they didn't even go to the jail, to the facility where father was. During that phone call, there was no service plan at that time. That they, well, actually, there was a service plan, and the service plan had 4 tasks on it for father.
The service plan was in May of 2021, right?
It was effective May 11th, 2021 through November of 2021. So the meeting, the social worker's first initial meeting with father did fall within that time frame. Now, the reason that this is an issue is because even though they knew that father could have been a putative father, they let him sit in jail.
So can I ask, when we're balancing who's got what obligation here, at what point is it really the department's role or responsibility to make efforts for someone who, in fairness, didn't appear to be making much of an effort himself to become involved in the child's life?
Well, that's interesting. That's an interesting question, Justice Brennan. And I will say that father did not know that he had a responsibility to this child. The child's paternity was called into question from the beginning. Right. Mother had, contacts such that would call the child's paternity into question. She'd represented to the department that that father one was the child's father, named the child after him. She had been in concurrent relationships with both fathers. So the record does indicate that father knew that there might have been a pregnancy and there might have been a child out there, but there was no confirmation, and the record's unclear as to, because he did have contact, or mother contacted him while he was in the facility. It was unclear as to when he thought actually that this child could have been his. Now, The social worker met with him in August of 2021. He was added to the petition in October of 2021. Even at that time, the department did not make any efforts to help him establish paternity. It was in October of 2021 when he was appointed counsel, finally.
So excuse me, so that's to my point. Just legally, what is their obligation to help someone establish paternity?
So the department would like to have things both ways. There was no difference in between these two putative fathers. The putative father, number one, there was no father listed on the birth certificate, but they made heroic efforts to provide him services, even though he wasn't listed on the birth certificate, even though the background of the two fathers was the same. Father one had a criminal history. This father had a criminal history. Father two was not listed on the birth certificate, or Father one was not on the birth certificate. Father two wasn't on the birth certificate, yet they provided visits to Father one, but then refused visits to my client because he had not established paternity when the other father hadn't established paternity either. Even when the first father
Isn't it the case that putative fathers are not entitled to visits in prison because of prison policy?
Not that I'm aware of, Justice Shin.
Okay. All right.
I mean, the DCF's or adoption of Jackie or care and protection of Jackie, in my recollection, I may have to write a letter on this, but, a father or a parent, a non-custodial parent in jail does not preclude him or her from receiving the services
That's
of
right,
the department.
once they're adjudicated to be the parent. But if you're a putative parent, are you aware one way or another whether prison policy would entitle them to have virtual visits or in-person visits?
Whether prison policy would?
Yep.
No, I'm not aware of that, Your Honor, but I do know personally of, and I don't know if this counts, of cases where, like I said, DCS has had it both ways. They've had fathers who are putative, yet they treat them as legal fathers until they establish paternity. And then they also have legal fathers whom, anyway, the department has had it both ways. Like I said, they offered this other putative father visits, and the only reason, I guess, the difference between the two was that my client was in jail, which could be considered discrimination against him because he was in jail. But going back to not only is he entitled, and this is kind of a theme, the theme that ran through the case is that even after he established paternity, and it did take a long time for paternity to be established, and that was through no fault of fathers, but even after that.
Do we know whose fault it was?
The record is unclear. I mean, the record says something about COVID, but COVID was 2020, and, would like the court to take judicial notice that, the emergency with COVID kind of occurred in May 2020, or March 2020. By the time father established paternity in November 2021,
It was still a pretty virtual world out there
It was
in the
still
court,
pretty-
in the trial court.
I mean, I
Correct.
didn't see anything in this record, though maybe I missed it, suggesting that it was DCF's fault that paternity took so long. It looked like it was probably the prison was the problem, kind of the sense I got.
yeah, father is not blaming DCF for the time it took, but father does take issue with the fact that that was one of the services or one of the things that they did not help him do. They did help the putative father number one establish paternity to rule him out, but my client was left to his own devices with his attorney, who was appointed 6 months after they became knowledgeable that he could have been the father. That complaint for paternity was filed in November of 2021. Then it took some 10 months for the adjudication to come in.
What accounted for, so I have that the action was filed in November 2021, but the motion for testing was not filed until July 2022. So what accounted for that delay?
The record is unclear on that.
He had counsel by this point.
Say again?
He had counsel by this point.
He did. He did have counsel at this point, but he also had DCF. And DCF, like you said, made heroic efforts to assist father
Going back
one.
to Justice Brennan's question, I'm not sure what obligation DCF has to help someone establish paternity, especially where that person has been appointed counsel.
I'd have to do some research on that, Justice Shin, but I will say, even if they weren't under an affirmative obligation, they were doing this for Father 1. Why didn't they do this for Father 2?
I don't understand why that matters. I mean, that DCF was giving services to someone else doesn't seem like a grounds to object to a termination.
Well, it's not that DCF was providing services to someone else that, that are the grounds, or that don't justify the grounds for termination. It is the fact that the lower court found that Father was, that his unfitness would endure to near certitude in such a way that it would justify termination of his parental rights. And Father's argument is that maybe if he had a little bit more help, maybe if DCF would have done a little bit more of what they promised to do under their action plan and what they're obligated to do under their policies, perhaps he would have been able to access services. He had an action plan. He is not the only one that had responsibilities. DCF also had responsibilities. They were supposed to meet with him monthly, even though in DCF's brief, they say that their policy is to meet with the parents regularly. But the action plan says meet with the family monthly. They did not.
I'm sorry to interrupt
Oh, no.
you. Finish. From your perspective, does the department have a greater obligation towards someone who's incarcerated? In other words, if your client were on the street at the time and they made the same effort and he made the same effort, are we in the same place or a different place?
DCF has the same, I'm not saying that DCF, or Father is not arguing that DCF has a heightened obligation because he is in prison, but they have an obligation to make reasonable efforts, and they did not do that. They didn't meet their own, they didn't even follow their own policies. Things that, they expect Father to comply with the service plan, they themselves did not comply with the service plan. As far as, making the necessary referrals. How could they know what the necessary referrals were when they didn't meet with him for 8 months? In DCF's own brief, they say that their social worker was on extended leave from August 2021 till April 2022. Trial testimony fleshes out she did not call the collaterals at the jail. She did not have any proof that he was in services because she didn't follow up on it. They had no interest. And I feel like the timeline is salient also, where DCF, they recognized that Father could have been a father in 2021 or February 2021. They met with him in August 2021. On October 1st, they filed their notice of intent. On October 26th, they added him to the petition, and then ignored him after that. It was almost as if they added him to the petition to terminate him. They did not provide the services that they were supposed to under their action plan, and certainly under Rashida. So not only is Father entitled to argue this for the first time on appeal, but he deserves a second chance for DCF to work with him, actually vet and investigate which services might he benefit from, having never parented a child, having had the history with law enforcement that he's had.
So given that, it's actually leading to kind of what I was going through my head, which is, it seems little doubt that the child was bonded with the foster parents. They were looking forward to, hopefully, adoption. And the father had spent probably good percentages, for better or for worse, and I'm not making a value judgment on that regard, better part of his adult life incarcerated with zero connection whatsoever to this child. So if we just look at the best interest of this child, how is the judge wrong, or how is the department wrong to come to the conclusion that this child's better served by maintaining this connection, being adopted, as opposed to kind of hoping that the father will suddenly have an epiphany?
So if we're looking at the standard of review on appeal, which is, was there an error, clear error, or abuse of discretion? Now, we have to concede that Father was unavailable at the time of trial, absolutely. But even where there are concerns about fitness, even where there are concerns, sure that the child's best interests, trump or prevail, the lower court is obligated under auto and the body of law that has come out of this court to make sure that DCF is held to task, They cannot seek termination of parental rights without first offering parents services, right, that they can access and they could benefit from. This is not what DCF did. DCF left him in jail to fend for himself, did not provide visits, and then used that to say, not only, he's lackadaisical, I think that was my words, but his disinterest in the child, it makes it in this child's best interest to be adopted by this non-kinship placement. Had DCF engaged earlier, perhaps his family could have been a viable option. But on the eve of trial, we tried to contact the family, it didn't work out. DCF did not do what they were supposed to do, and father believes that he should be given a chance.
What do we do with the fact that he didn't ask for visitation for 5 months after paternity was established?
I think the record reflects that, DCF did offer a visit, that he did not want the visit to take place at the jail. And I think we can take that as father looking out for this child's best interest. But these cases are complicated, as we all know. And, father has stated that he wants the child, he wants to be a father to the child if he can. If not, he wants the child connected to his family. But the lower court found that even though father did not ask for them, DCF had an obligation to make them happen. And they didn't, even after paternity was established. They made all excuses. They created these obstacles. They moved the child 3 hours across state lines and then made all of the excuses why they couldn't bring him back to visit father. I see my time is winding down. But
Your time's up, but you can finish
it's
your
over,
thought.
I'm
Yeah.
sorry, yes, but.
You can finish your thought if you like.
Okay. But father would like a remand so that we can determine whether his unfitness was just temporary based on the defects in DCF services. Thank you, Your Honors.
Thank you very much.
Good morning. May it please the court. Lynn Murphy for the Department of Children and Families. This case is not like Chad in any aspect.
Not like what, I'm sorry?
The case before you today is nothing like adoption of Chad. There was no issue of services raised at any time by this father, even when he had counsel. He had counsel for a year, and no abuse of discretion motions were filed, and a permanency hearing was held, and father did not, at that point, object to the services provided by the department. And at that point, as I said, he was represented by counsel. The court found that the department's efforts were reasonable under the circumstances. The department is to provide reasonable efforts, not extraordinary efforts, and the circumstances that existed.
All right, well, let's talk about that. Regulation 110 says the department's efforts shall include regular visitation at the correctional facility, as well as the holding of case conferences and other consultations at the correctional facility. And even when he requested it, you didn't do that, right?
Even when he requested?
When he requested visitation, that was not done, right?
Well, he requested visitation in February, the last month of trial, and at that point, the child's counsel filed a motion to stay visits, and the department was in the midst of considering that. The problem was...
That's what I don't understand. I look at social worker Finn's testimony. Here's someone who asked for visits, which the regulation says has to happen, and she says it's been talked about and discussed with the clinical team.
Right.
So we'd like to acknowledge that what's in the best interest of child, taking him where he has never met father, taking him to jail, the impact that would have on the child. And that there were 3 meetings, and it was up to someone else. And I don't understand how there could be even 1 meeting when the regulation says there shall be visits.
Because we offered visits and the father rejected those visits.
Yeah, but then when he asked for a visit, and the regulation says there shall be visits, why there have to be 3 meetings with the
Because
clinical
with
team?
father being in prison, it's not that easy. It's not as if we could set up visits immediately. You have to confer with the prison, figure out how you're going to
Yeah,
do
but
it.
that's not what social worker Finn said. She said that DCF was discussing whether to give him visits. That's what you said originally when you started this argument. And I don't understand. I can understand it might take some time, although I can't see how it would take this long to set up a visit. But from the record, it seems like DCF was deciding whether or not they were going to follow their regulation. Is that what happens?
No, I don't. I think because of the lateness of the request by father, there were some logistics involved with father being in prison. And there is a discussion on the record where the attorneys are explaining, maybe we could do this by FaceTime, maybe we could do some kind of video conferencing. But at this point, the trial has been underway and it's almost over. The child has no relationship with the father. And as I said, the child's own counsel filed a motion to stay because, remember, the visits do have to be in the child's best interest, or it could be harmful. If the visits are harmful, then the judge can rule in that. But there wasn't sufficient time to even get to that point because by the time father wanted the visits, trial had been underway several months and was about to conclude.
So just to be clear, DCF's view is that if an incarcerated person wants visits, they get visits.
Yes.
It has to be logistically figured out, but
Right.
there's no, maybe we give them visits if it's in the child's.
No,
Okay.
absolutely not. I think the difficulty, and that's really the key to this case. The department has to make reasonable efforts given the circumstances of each situation.
When does the department's obligation kick in with respect to a putative father?
Well, here's what happened in this case.
When does DCF have the obligation? At what point
The
does it
department
start?
has no obligation to provide putative fathers with any visits. But what the department does do, and what it did in this case, the department can offer those visits and did with Father One because he acted like the father. The children knew him as the father, so the department treated him as such until the time we realized he was not the father.
So they have no obligation until paternity is established to provide any services to a putative father? I mean, it happens all the time, right? We see the cases all
Visits,
the
I
time.
thought you asked me visits.
Services.
Services. Well, services, yes, there should be services to a putative father.
At what point does that obligation kick in?
Well, we have to know that it is the father. In this case, we
Well, I
had
don't understand
no-
that. So the mother tells DCF for the first time in February of 2021
Right,
that the father might be the biological father. Is that when the obligation kicks in?
yes, because before that, the department didn't even know
Okay.
of the existence of father.
So
In fact,
February
we had-
2021, department has the obligation to make reasonable efforts, and they don't seem to really do anything. And
We
you said
developed
that
this-
the social worker is on extended leave between August 2021 and April 2022, didn't meet with him at all during that time. That's 8 months.
Right, that is unfortunate, and.
Well,
but
it's
the
more than
department-
unfortunate.
But I would call your attention to the fact that the department developed the service plan within 2 months after being told about putative father. And we did meet with him, I believe the record shows, in August. Another 2 months or 3 months later, the department did meet with father. Unfortunately.
Would you agree that the services that were provided would have been far short of reasonable had this been the father from day one? If this is the father from day one, that what the department offered and provided was inadequate. You agree with that?
Well, again, the circumstances of father being in prison makes it very difficult. When you have a father in prison, you can't make referrals. You cannot talk to collaterals. You need a release. You can't assess someone
So this
easily.
doesn't turn on him being the putative father versus the established father through DNA versus maybe he's a father, but we don't really know who's the father here. It doesn't.
Well, I
that's not
think it's
relevant?
unfortunately, these cases turn on the facts. And in this particular case, the department had serviced this family for 8 months, having no idea who this father was. By the time mother said, I think this is the father, and we had discussions about moving forward, we developed a service plan, we met with father. There were lapses, as the judge noticed, but in the end of the day, this individual didn't meet his own obligation. He was supposed to contact the department as well. He said in April 2022, oh, I'm enrolled in parenting and I'm doing a criminal thinking class. That was not the case. He was not enrolled. He never did it.
It just seems to me it can't be right that, and I'm not saying it's a situation here, but someone makes, call it a mistake, and ends up getting a 5-year minimum mandatory sentence, and that based on that, they lose any and all rights to be a father to a child. Or
Absolutely not, Your Honor.
Okay,
Absolutely
so
not.
talk me through what was different here.
Absolutely not. I mean, if this father had made efforts to show he was interested in parenting his child, he did what he needed to do. He attempted to try to contact the department. He attempted to really do services and just instead of saying he was going to do them, and he never did. Even at trial, his testimony was very thin. He didn't have this great plan. In fact, he had no plan, the judge found. This was an individual who did not do his duties under the service plan.
Can I ask you just one question for my own edification? The social worker didn't seem to know whether she could accept collect calls from a father in a correctional facility. Do you know the answer to that? I know they don't do collect calls anymore, but do you know whether they're allowed to?
That's a good question. I would think that the department would be able to accept collect calls, and I think we have done that in the past. Whether the other unfortunate issue was this was a brand-new social worker who testified. She was just on the case maybe a couple months.
It reads that way.
Pardon?
It reads that way.
Yes.
Do the prisons allow visits with putative fathers?
The
prisons allow visits with...
They do.
They do?
But,
Okay.
I mean, you have to go through the process.
With putative fathers have the right to visit?
Yes,
Okay.
yes, they would be. But again, it's the department would have to set those up. You have to work with the prison. It's not as easy as when you have a father not in prison, that we can start those visits immediately. But when you have to go through the prison system, you have to be vetted. It has to be, there's other hoops for the department to jump through, in other words.
All right, thank you very much.
There are no further questions. Rest of my brief.
Good morning, if it pleases the court. My name is Mark DeJoy. I represent a 5-year-old child who was 3.5 years old at the time of trial. He's never met his father. I'm going to go back to Justice Brennan when you said judge the balancing test. I think the trial judge was there trying to figure out who's supposed to do more. He said 50-50, 70-30. I'm not really sure, but in going to Judge Ditkoff's point about the father not wanting to have visits, at least said twice, it seems, the record, that he didn't want it early on and then in December, that engagement with the child would allow the trial court to have some idea whether he could parent, whether there was a bond. The problem here, we don't have a bond at all with this father, and the adoptive parents with his sister, who's lived with this entire life. The judge found that there was a great bond there, that they supported him, that he seeks their approval and comfort when he's stressed. The issue of the reasonableness, whether it was preserved or should have been here, I think the appellant needs to show that there's some sort of harm that was caused. And I would suggest, Your Honor, if they did get to the jail and provided the services that he wanted, we would still be in almost the same situation. The father would not have a bonding because he didn't go to visits. He would still be in jail long after the trial. The trial judge would have been faced with the same information. And even if you found that there was clear error, the judge, without finding of harm, the judge could still render the same decision that she did. And even in Alona, if the judge did not find that there was reasonable efforts on behalf of the department, she's not precluded from doing the same exact thing that she did, was find the father unfit, release the child to be adopted, and on behalf of my 5-year-old client, he would ask that you affirm the lower court. If there's any other questions, I'll rest on my brief, but I'll be happy to answer any questions.
I think we're all set, counsel. Thank you very much.
Thank you, Judge.
Thanks to all of you. The case is submitted, and we are in recess.